Okay, we are live, I think.
Great, we're live. We're starting a couple minutes late and got our weekly update coming. So my name is Aaron Hall. I'm here with Rylan Warner and Jennifer Howard for this week's update. And we are going to get through a couple of issues that we wanted to talk about, and then we'd be happy to take questions in the comments and provide answers as we can. So why don't I start? I wanted to talk a little bit about the diversity visa program and the DV 2022 litigation that is upcoming. And I'm going to wind it back a little bit to start. So if we're talking about the DV program, this is a program that is 55,000 visas per year. And it's a lottery. People enter, they get selected, and then they have to apply at the consulate. And if it is approved, then they come in as permanent residents. Well, this was not a very popular with our last popular program with our last president. President Trump often railed against this program and said he wanted to eliminate it, wanted Congress to eliminate it, but he never convinced Congress to do so. And so what he and his administration did over the course of the last few years was just decimate it through executive actions. The first thing they did during COVID was they barred DV applicants through an immigrant visa ban. They barred other applicants as well, but DV was one of the categories that was barred from entry to the United States. And they did that on a pretext that it was keeping us safe from COVID somehow. And they said that during that ban, they wouldn't even process visa applications. Then after that, they also made a policy deprioritizing DV visas in general, so that even after these, the bar was lifted through lawsuits and through finally President Biden lifting the presidential proclamation, it was still the last priority amongst immigrant visas for consulates to consider. And what that meant was that they were hardly being considered at all and hardly being processed at all, even under Biden. So instead of 55,000 visas being processed, it was reduced to a trickle. And even though the Biden administration lifted the proclamation, they did not change the priorities that had been put into place in November of 2020 by President Trump. And in fact, they defended them in court. So we get up to 2021, and one of the lawsuits, we all worked on was called Go v. Blinken, and one of the challenges in that was to this prioritization. And the judge found that it was unlawful as applied to DV 2021, the past fiscal year. So what happens then? They see the writing on the wall a little bit for 2022, and eventually in November of 2021, they released something saying that the consulates should no longer rely on this prioritization scheme, which had been deemed unlawful, even for 2022 people. So that seems like good news, but what has it resulted in? Well, it didn't result in applications being processed, at least not as of yet. And the way that I've been trying to conceptualize it for myself, you'll have to indulge me here for a minute, is I'm thinking of a highway or a road that runs along a cliff, and you're the passenger in a car, and the driver is driving along the road in the lane, and then turns towards the cliff. So you're now driving towards the cliff, and you say to the driver, "Hey, stop driving me off this cliff." And the driver just takes his hands off the wheel and takes his foot off the gas pedal, but doesn't do anything further. The car's still headed towards the cliff. That's kind of where we are right now. They've taken away the prioritization. They've taken away the no visa bans, but the DV program is still going off a cliff because they haven't taken corrective action to make sure that the consulates process the applications on a par with how they processed them in 2019 and before. And because of that, hardly any have been processed thus far yet in fiscal year 2022, which started in October. as of yesterday, I think that there were 300 some diversity visas that had been issued in fiscal year 2022. We would expect that over 50,000 would be processed during the year. So we are not on pace. The immigrant visas, immediate relative visas, which are just kind of something helpful to measure against to see, well, is that just because COVID isn't letting them process visas? What's going on here? They're actually on pace to exceed pre-pandemic processing for this year. So it's not that. It's not that the consulates aren't working. It's not that that there is just too much pandemic to deal with. They're processing visas. They're just deprioritizing diversity visas, even though they formally took away that prioritization memo. So that is why we have to take some action here. Oh, one other thing. In a separate case, in Gomez case, which is the 2020 case, the government recently had to make a status report. And in it, they represented that for various reasons, they were front-loading DV-22 cases, meaning that they are trying to get most of them done early in the year. Well, that's really concerning because they haven't gotten any done. They've only gotten 300 done. And so for that reason, we're getting ready to challenge this and say, listen, you have to order the Department of State and the consulates to take a corrective action, to give corrective guidance to process visas on a par with what we would expect in the pre-pandemic period. So that's what we're preparing. We're starting to prepare. We're starting the onboarding. I wanted to see if Rylan, because he has the controls here, I'm going to put in the private chat the link to the onboarding page. Rylan, I don't know if you can post that so that people can see where to get more information.
Yeah, I'll do that.
But for people who are considering taking part in litigation, now we have a deadline, I think, of next Friday to get kind of the early bird discounted version of signing up for this litigation. It's something that we absolutely know is necessary. The government's not going to move on these cases without litigation. They've showed it, and so we want to get a start on it as soon as possible. Take a look at the FAQ and let us know if you have questions. And we will, as an aside, we'll be doing a full hour, likely a full hour on this on a video tomorrow. That would be Friday morning at 8 o'clock Mountain Time. So you can also tune into that for further information about this. So that's what I've got on the very concerning situation with DV 2022. Rylan, I want to pass it over to you for your update.
Sure, yeah. I wonder how many years in a row are we going to continue doing this?
I mean, people might not believe me, and I would tell this to a judge too. I was so hopeful and expecting that we might actually not have to be back litigating diversity visas again this year. I was thinking, they've lost a couple times in a row. They're really going to get the message and start processing them. No.
Yeah. Okay, well, fingers crossed next year they'll finally start processing them in a timely fashion. But until then, I'll keep the link that Aaron shared with me down below scrolling. I know it's not ideal that it's scrolling, but it's the only way that I can keep it there while I bring my own banner up. So I'm not sure when exactly. I think it was sometime this week. It might have been yesterday. But the Supreme Court heard argumentation about these two cases about indefinite detention of people that are in the United States that were previously ordered removed and then re-entered and are now seeking withholding of removal. So asylum, I'm sure a lot of people have heard of asylum before. Asylum protection is for people that have been persecuted or have a well-founded fear of persecution on account of a protected ground, which there are very specific grounds, but it's basically you're targeted because of something about yourself that you can't really change or you shouldn't be expected to change about yourself. And for asylum, you need at least a 10% likelihood that persecution will occur to you in order to have a well-founded fear if something hasn't happened to you before. But for people that have been previously ordered removed from the United States, or they just didn't happen to apply for asylum protection within 1 year of entry to the United States, those people cannot apply for asylum. But instead, what they could apply for is withholding of removal. And it's basically the same thing as asylum, but there needs to be a higher likelihood that you would actually be targeted and persecuted in your home country. It's more likely than not, or 51%. And it also is a more limited protection. I mean, it doesn't give you as many benefits as asylum does. For instance, asylum applicants or asylum green card holders, they can then apply for family members. Withholding of removal, they don't get that same opportunity. So it's a worse benefit, and it's harder to achieve, harder to obtain, but it still serves as kind of a last opportunity for people that aren't otherwise eligible for asylum. So these Supreme Court cases are about people applying for withholding of removal because they had previously been ordered removed from the United States and then re-entered, and now they're in detention facilities. And they are in the process of USCIS and ICE and Department of Homeland Security trying to get them removed again from the country. But they're saying, hey, wait, no, I qualify for withholding of removal protection. Please just hear my case. And while they're waiting for their cases to be heard, they can sit there for an indefinite amount of time, just in this terrible condition, detention facility where they're exposed to COVID all the time. They I mean, whether or not it's bad conditions, the fact that you're in a detention facility for who knows how long, it has a huge impact on human wealth and welfare. It can have a huge impact on your psychological well-being. And so these lawsuits, they're from the Third and Ninth Circuit, and the Supreme Court is hearing them both simultaneously because they have very similar facts. And they're in those circuits, cases have been fought and won, stating that people should be eligible if they are looking for withholding of removal. They should be eligible to go in front of an immigration judge and have a bond hearing. In which they would say, hey, I'm not a threat to the community. There's no real risk of me running away. I'm willing to give you money. I'm willing to wear a tracking bracelet as long as you just please let me out of this detention facility while my case is pending. And then when the case is finally ready to be judged, I'll come back and we can do this. But in the meantime, please just don't keep me in here. And both of these cases are about whether or not these people should even be given the opportunity to request bail or request bond to be allowed out while their case is still pending. And the Biden Department of Justice is saying no. They should not be given this opportunity. They've already been removed once before. They came back, whether or not they are actually eligible for withholding of removal, because they could actually be persecuted in a foreign country. It doesn't really matter to us. Keep them in there for however long we deem is necessary. Could be a year, could be multiple years that you're being held in this facility. And it's just absolutely absurd. It's frustrating to me that the Biden Department of Justice is taking up this case to fight. Aaron, I wasn't really sure. I know this represents a Trump era belief of no, they shouldn't be eligible for bond or parole, but I wasn't sure if you had any idea of why the new Department of Justice under Biden would still be fighting for the same Trump era policy that is, I would hope that we would be trying to move past, but I guess not. Do you have any inkling as to why that would be?
Yeah, well, I would say the Trump administration surely wanted to detain as many non-citizens as they could, but the Department of Justice, I think, has been litigating hard on detention issues and in favor of an expansive view of the detention statutes, between various administrations. So, definitely going back to Bush, and then under Obama, and certainly under Trump as well. So I'm not shocked, but I agree with you. I'm disappointed that we can't move on beyond a Department of Homeland Security and a Department of Justice that want to use the detention of people who don't happen to have been born here in the United States as a widespread policy. It doesn't make any sense to me. It's really expensive to the taxpayer. More importantly, it's like you said, Ryland, it's just taking away a human being's liberty and caging them for no reason. I mean, for an alleged civil violation. It's not criminal detention or anything like that. So one thing I would point out, I always go back to a bit before she started running for president, Vice President Kamala Harris actually made a big splash about being against immigration detention and wanting to eliminate it. But we're not seeing that from this administration by any means. So hopefully this case will come out the right way. I'm nervous about it. I listened to part of the argument, and the advocates did a great job, but I don't have a ton of confidence that the justices will go the right way. But I hope I'm wrong. I hope that they do.
Yeah, and there is some case law here that was decided by one of the justices. I don't have the case in front of me, but it was.
Yeah, the argument was relying on I think it was a early 2000s case called Zavidas, and it was Justice Breyer who actually wrote the 5-4 opinion. So everybody was referring back to that in the argument. So
yeah,
we shall see.
Yeah, and even with that case law on the books, there were still justices saying, "Yeah, we need to respect this case law, but at the same time, do we really want to?" So, yeah, it's disappointing. I looked into a little bit of Garland's defense of still maintaining Trump era policies or defending them in court, and he says, this office isn't supposed to be political. We're just supposed to address things in a legal fashion, which that's all fine and good until the other side is like, I don't care about that. I'm going to completely embrace politics and do whatever I want for this. And then it shifts back to our side or whatever side. And we're going to keep fighting those same battles. It's just absurd. But hopefully there's something good that comes of this, but I won't hold my breath just yet. Okay, Jennifer, do you have a topic you'd like to talk about?
Yes. So I was just going to give an update. And Aaron, you may know a little bit more about this, but currently the Denver Immigration Court is doing all of their hearings for the rest of January via WebEx or telephone. And I guess what I'm not clear on, because they came out with an announcement last week that they were canceling all the hearings, and then they came back and said, no, we're not canceling the hearings. They're going to actually proceed via WebEx or telephonic. And I know originally that was going to be an option. The WebEx or telephonic was going to be an option for represented respondents, so people with attorneys. And so now what I'm not clear on is, are unrepresented respondents still going forward via WebEx or telephone? And from reading this, it sounds like it is, because it says, we understand that respondents have, varied access, but like most people should have access to a phone or some way to access the internet. And so I'm not sure what they're going to do if someone doesn't have that, because I know for us, I've been having clients come into the office when we have WebEx or telephonic hearings, just because we have stable Wi-Fi, we have a computer system, we have video cameras, and I know especially for our mountain clients, they might not have a stable connection things like that. And so I'm not sure what's going to happen with all that, but it's right now it's just for the next couple of weeks for the rest of January. And this is because of the outbreaks, the Omicron outbreaks and everything. It's been pretty crazy in Denver. So.
Yeah, I think my understanding, to be honest, it's been like pretty confusing to read the various standing orders and cancellations of standing orders and tweets and emails and trying to piece it all together. But my understanding right now is that the non-represented people, the pro se people, are actually not going to go forward at all. That language about their access to the technology is about them appearing from a separate location from their attorney when they do have an attorney. Because at first, some courts were trying to require people to appear from the same location as their client. And attorneys and respondents, I assume, were justifiably upset because they were saying, there's too much spread for us to be in court, but you want us to go get in the same room for 3 hours and have a hearing. So UAR, to their credits, they did say that you don't have to be in the same location, but that brings up other problems like access to technology. And so that's what they're talking about. But, I'm trying to picture somebody, some people's only access might be by their phone. So if they're appearing by video from their phone and trying to do testimony for a multi-hour hearing, and the judge is trying to evaluate credibility, it does not seem ideal. So, but yeah, so it's chaos in the immigration courts.
Yes, to say the least. And of course, we have random closures where staff have been exposed and hearings get canceled. So if you are a client, your hearing gets canceled, know that we're trying our best. And the court really they're trying their best too.
Yeah, true.
We're all dealing with this. So.
All right, should we get to some questions?
Sure, it looks like we have a couple, right?
Yeah. Ronald DaCosta. Let me try to raise my head up. Ronald DaCosta says, "Hi, I'm a Go plaintiff. I've seen Ronald here before.
Mm-hmm.
I'm one of the 246 DQ'd plaintiffs. He was documentary qualified in late April. Since the judge reserved 481 visas, what are his chances?" Aaron, specifically.
Hello, Ronald. What are your chances specifically? It would be doing baseless speculation. I don't know to what extent the 481 visas will go to people who are already deemed documentarily qualified first, that were already previously deemed documentarily qualified. I just don't know that. As we've told our Go plaintiffs, we're not going to get into advocating for one group of Go plaintiffs over another, or vice versa. So our only role is to make sure that they process the visas, all of them, in accordance with the order. And the order is only that they finish processing them by the end of this fiscal year. So that's September 30th of 2022. Now, it's frustrating because they haven't started, and they're not going to start until at least April. So they're basically pushing it towards the last minute, and we have no indication about how exactly it's going to go. I can actually see your next question, Ronald. It's about communications with the government lawyers. So that leads into this. The government lawyers have not given us any information about how these reserve visas will be processed. Regarding appealing the case, they asked for more time to get authorization, or to see if they have authorization from the higher ups in the Department of Justice, specifically the Solicitor General's office, to appeal. Apparently they don't have it yet, that authorization. My take was, well, if you don't have authorization to appeal, then don't appeal. That sounds easy. But they asked the court for a delay of their deadlines, and they basically get an automatic extension through their own filing, and we don't have the court coming in yet with a hard deadline on them. So no substantive communications about the appeal. We're waiting for word basically from them about whether they have permission to continue with the appeal. If they don't, then the appeal will be dropped, and the Department of State will be tasked with implementing the judge's order and producing and issuing those visas.
All right. Then we have one last question from EJAZ asking if there's any update about humanitarian parole. I don't know that I've heard any broad patterns that have been revealed. I know that we've mentioned about the huge backlog for Afghan cases and how there's a limited amount of workers actually processing them. But I don't know if there has been an official announcement of any update. Have we had any of our, I don't know if we've had any in our office that have been approved yet. We're still waiting on those. But yeah, have you guys heard anything differently?
No. I'm going to limit this. I'm going to make an assumption that the question is about the Afghan cases. We have not gotten them on our cases. We have not heard any. There haven't been any announcements from the government or anything like that. There are starting to come denials from other attorneys around the country who are sharing redacted versions of their denials, and it is quite dispiriting. They are some of the denials that I've seen. Actually, Greg Siskind, our colleague in our impact collaboration, he shared one that had it was a one line of reasoning, saying that they reviewed the application and the law and regulations and policies, and that they've decided to deny the application with no further detail about why. And it sounded from Greg's description like it was a very meritorious case. So beyond that, nothing. I can tell you that a lot of people are in discussions and in our collaboration and in other places about whether there's going to be need to be litigation about the way that these Afghan humanitarian parole applications have been processed and decided. So if there's news there, we will certainly share it.
I wonder if we'll hear about any Afghans crossing the southern border, and then MPP will be extended to include the entire world rather than just the southern hemisphere. We'll see. I hope not. But when you are not approving these humanitarian parole applications in like the most applicable situation, what are people to do? It's very frustrating. Well, Ronald says thank you as a way to end on a lighter note.
All right. Okay. Anything else, Jennifer or Rylan?
No.
Rylan, when we started a couple minutes late, and neither Jennifer nor I could figure out how to take the helm and control this and start it on time. So just know that that nothing can happen without you. Thank you. Thank you both, and thank you to everybody watching. And we will be back next week.
Yeah. Bye.
Thanks.